we are going to be talking about both policy and regulatory issues that you will encounter as startup builders, and we hope that you will find the information useful. My background is that I was a prosecutor for many years at the Department of Justice, and then was working on regulatory matters over at the Department of Treasury. And I'm happy to be here with our global head of policy, who equally has an interesting background working both inside and outside of the government.
Thank you, everyone. It's so exciting to be with you. I'm Brian Quintenz. I'm the global head of policy for the crypto team. We're both very excited to be with you and spend some time getting to know you today and tomorrow for some exciting discussions and some exciting events. Before I came to A16Z Crypto, I was a commissioner of the Commodity Futures Trading Commission. That is the derivatives regulator in the United States. We have kind of two different market regulators in the US. The Securities and Exchange Commission regulates the stock market and the bond market, and the CFTC regulates the derivatives markets. And while I was there, the agency was really just getting into crypto and decentralized concepts. And it led very well into this role, where we are trying to develop policy frameworks that fit the technology and that appropriately address risks. And so with that, we'll give a little bit of a distinction between policy and regulatory.
So a lot of people like to put together policy and regulatory in one box. And that makes a lot of sense, because we do, particularly at A16Z, work together in parallel on policy and regulatory matters. They go hand in hand. But just to be clear, the differences between our roles. With policy, this is where we're looking to affect what the laws and the regulations are going to be going forward. That's a really important role, both in the United States and internationally, because, as you all know, the laws are still in development and we actually can't affect what they are. With regulatory, this is about what are the laws on the books right now that if I'm running a business, I need to be aware of and I need to be complying with. And so those are the differences. And so our presentations will reflect that. And I think that's it.
Yeah, and I think the other important thing is that we work incredibly closely together. There's often a lot of overlap between our teams and with our legal team and with our government affairs team. So while we are kind of an inseparable group, we do try to define some boundaries and have leads on different issues or different work streams. And so since we're we're developing broad frameworks first for policy outcomes, right? So it's important to have a set of first principles, from which everything else can flow. The first that we've established is that regulations and legislation should reflect democratic values. Obviously, we think this technology is important, and it shouldn't be used to impose things like censorship or control or surveillance obligations, or create new powers that don't exist and that match the values of democratic governments, such as individual freedom, the right to transact, respecting individuals' legal privacy, and competition, promoting competition as opposed to regulatory capture. Secondly, new rules, new laws should be appropriate and clear. And so when we think about kind of appropriately framed constructs, we're talking about what is the scope? What's the scope of the audience that a regulation or a law is intended to address? Is it targeting the right risks? And are the rules something with which those targets and that risk, the targets can comply with, and that manages that risk appropriately? One example to kind of think about there is, let's say the government wanted to regulate self-driving cars, autonomous vehicles, but it created a definition that was really broad that then scoped in things like functionality around cruise control. Right, so appropriately calibrating the scope of a rule, addressing the actual risk, and then ensuring that the outcomes of those rules are calibrated so that the entities can comply with them and they target the right activities. Thirdly, legal businesses deserve access to legal services. That is a main principle for us, and we see some challenges with that. There are currently a lot of discussions and issues, certainly around access to banking services and around some other access to services, and we think it's very important that if businesses are legal, that they can't be censored out of other legitimate services that the rest of the economy has access to. And finally, kind of a construct that we talk a lot about with policymakers is don't regulate software, regulate businesses. In our parlance, that's, regulate applications, don't regulate protocols. And those are clear distinctions that we try to make with policymakers so that they understand, again, back to kind of that second bucket, how to appropriately target, scope, potential rules. I'm going to go into more of the policy overview, and then we'll turn it over to Michele. What are the policy issues that we're trying to solve? Right. Again, coming down from those frameworks that we've established. I think most policymakers try to think about or end up scoping in all the activity in blockchains into financial services rules and laws. But legacy financial services and rules do not fit this technology. They were designed a long time ago. They were designed for centralized entities that created centralized risk. So they don't match what we are trying to accomplish here, and they don't address any of the remaining risks or new risks of the technology. So what are a couple buckets there that we're focused on? Well, how to launch a token, right? There is a lot of discussion. I know a number of your teams are thinking about this process. And launching a token has a lot of legal and regulatory concerns around it. And we want governments to recognize that the true benefit of this technology is decentralization. From the benefits that itself provides, but also the benefits that provides to consumer protection. That you have a lack of a centralized management team, a lack of asymmetric information between a consumer and the purchase of a product. So how do we create rules that recognize decentralization as a benefit, and that then give founders a clear path in a government, recognized way to building and launching a token that users can purchase and ultimately use or consume. Second is, how do we think about DeFi? DeFi, it's important to note that a lot of conversations we have with policymakers around decentralization, when we say decentralization, they think of DeFi. And that's if they have some familiarity with DeFi at all. And so the first thing is that we try to broaden the aperture there to focus decentralization on something much more general than just DeFi. But then if they do want to talk about DeFi and we need to address DeFi, how do we think about that? And I think that gets back to kind of one of those first principles standpoints about, if you regulate a business for the risks that it poses, you don't regulate software that anyone can access. And so Miles Jennings has published extensively on this. We have, I think, 5 parts to a series called Regulate Apps and Not Protocols. I was pleased to join him in publishing 2 of those that give a lot of thinking about how to potentially create regulatory obligations for businesses and apps that are facilitating access to DeFi services that can provide integrity to those marketplaces and to consumers that are transacting there. And then the third is kind of stablecoins and staking. Those are very prominent discussions right now in the UK. HM Treasury has announced that they are expediting work on creating stablecoin and staking policy and trying to finalize that by the end of this quarter, Q2. And so it's important that we distinguish what the risks are between different models there. And again, this comes back to centralized versus decentralized. When you have centralized services, you have issues of trust. You have custody. You have transmission of funds. You have the investment of those funds into products and collateral that can create risks. Whereas if things are decentralized, they solve a lot. They solve a lot of those problems. They obviate the need for a lot of the regulations designed to address those concerns. But then how do we think about what the appropriate mechanism is to address any remaining risks, like the integrity of the software, the capabilities of the protocol, the ability for the protocol or the software to be changed. So I also wanted to talk a little bit about some of the things that we hear from policymakers, and I think it's important to kind of separate these discussions or potential audiences into 2 different buckets. The first bucket are conversations had in good faith with people that are honestly and legitimately skeptical of the technology, possibly ignorant of the technology, but that want to have a good faith discussion about what it is, what the innovation, how much innovation exists in this ecosystem, how they can embrace the benefits and try to cabin the risks, versus some policymakers just have a political hostile view towards the technology, and that either requires a different kind of engagement, or it may not be a fruitful discussion. And so I think the first part is recognizing who your audience is, and even with policymakers that are legitimately skeptical and have some self-aware ignorance. A lot of times we hear, a number of different kind of refrains that I think reflect, a couple of, either the underlying beliefs or the things to which they're the most exposed. I think everyone has to remember policymakers are extraordinarily busy. In their roles, they are responsible to have thoughts and positions on every single major policy issue, every single front page news item. They are often booked in 30-minute increments throughout the entire day, every week of the year. And so it's about trying to cut through and meet them where they are, right? If they're giving us feedback about what they know or what they have heard, we try to answer those concerns. And oftentimes this boils down to, them thinking about blockchains and crypto assets as being Bitcoin, as being FTX, or as being, DeFi, if they've done, any amount of research and they can get that far. And so some of the things that we've heard, for instance, are, I like blockchain, but I don't like crypto. When I hear that, what I translate that into is I really like innovation, but I really don't like speculation. And that's something we can work with, right? So the first step we take there is we say, you can't have decentralized blockchains without crypto assets, right? They're integral, they are linked. And so let's push down on, right? Let's target the innovation that we are seeing in this space. And then let's also address, the speculative aspects of the ecosystem. And oftentimes we go through the Web 1, Web 2, Web 3 model with them so that they understand what the true benefits are and potential is of the technology. And then we also use Chris Dixon's, incredible framing from Read Write Own about the world computer versus the world casino. And when you have kind of the world casino aspect that's based in centralized entities, it's legitimate for policymakers to be concerned about that. But what we don't want them to think is that that's the only thing that exists. So we focus on use cases, right? What are the use cases that are the most tangible for them, that solve the problems that they are concerned about? Secondly, crypto's the Wild West. There are no rules, people do whatever they want, and it's all illegal. The reality is there are a lot of rules that are already applied to crypto. Michelle's going to talk a lot about some of those in her presentation. So we try to address some of those concerns and let them know that all these laws that you've worked on or that have existed for a long time already apply to activities in this space. And so you don't necessarily have to be as concerned about those aspects as you think you are. The third is the same activity means the same risks, means the same rules. This is a little bit of a political tagline, and we've heard this mantra in the United States to some degree and a lot out of the EU. And it in my view, it deserves kind of some unique focus and some special attention, because I'm not sure people really mean it when they say it. Because as I look at that, I'm asking myself, those are two questions followed by a statement, right? Is it the same activity and does it pose the same risks? Therefore, there should be the same rules, Or said differently, if it is the same activity and it is the same and there are the same risks, we should have the same regulatory outcomes. Maybe not the same rules if the rules don't fit the technology. But a lot of policymakers think, well, if you're doing X and X is regulated in the financial markets, it doesn't matter how you do it, we need to bucket you into this bucket of a legacy rule set. So oftentimes we're trying to walk through, what is the activity? How is it done? Again, how does the benefits of the technology obviate the need for prior regulations, and what are some of the new risks that need to be addressed? And lastly, I'm worried about crypto and illicit finance, and this is something that Michelle's going to speak a lot about, and she has a lot of expertise on. And a lot of this comes down to data, right? We try to be data-driven in everything we do. The fund published a State of Crypto Policy report about a year ago where we go through a lot of different data around some of these misconceptions like energy usage, also around illicit finance, talking about the amount of crypto transactions that are actually used in illicit finance, which is a tiny percentage compared to the amount of cash that is used in transactions, which is a much larger percentage and a much, much larger nominal amount. And so while this is definitely a concern for everybody, we also need to scale the problem appropriately and make sure that we're not addressing it through a means that destroys the benefits of the technology. Lastly, I just wanted to quickly go through where we are on an international policy perspective. Here's a little geography quiz. Hopefully everyone knows the first flag since we're in the UK. I've been spending a lot of time in the UK. I think one of the reasons we decided to open our first ever international office in the UK was to embrace the current government's approach to crypto asset regulation. HM Treasury released a consultation at the beginning of last year and then issued a response to its own consultation at the end of last year, where they had what I thought was some of the most nuanced thinking and appropriately calibrated thinking around crypto asset regulation. They said things like airdrops are an important part of the crypto ecosystem and important to achieving decentralization. They had a nuanced discussion around staking. They declared that it was not their intention to ban DeFi. NFTs are out of scope for now. So some very actually nuanced thinking that we haven't seen from other regulatory jurisdictions, that they are in the process of trying to put some meat on the bones now and bring into the regulatory perimeter in the near term. There will be more work to do over the next months and years. There's likely to be an election here in the UK sometime between now and the end of the year, and we are preparing for all potential outcomes there. And there will likely be more work to do to try to finalize that regime in a way that respects the technology and appropriately provides customers protection. The EU has brought on the MiCA regime, or the MiCA regime. That is a pretty comprehensive approach to regulating crypto assets and centralized intermediaries. But it's up to now the regulators to interpret that text. And some of the signs that we've seen from the regulators are a little bit concerning. There's also an interesting interplay between the state country regulatory system and the national EU-wide regulator ESMA. So we're following that closely to see how that evolves. But there are some concerning signs, and we've provided a lot of comments and feedback to ESMA. Japan, Singapore, and Korea are also very advanced in thinking about how to regulate activities through centralized intermediaries. As we are engaging with them, we are again focusing on ideas that don't enshrine centralized concepts in the regulatory obligations that would preclude projects from decentralizing. When you think about a disclosure framework, for instance, for crypto assets, is it an issuer-based disclosure framework where you're talking about the financial condition of a management team or a company? Or is it an asset-based disclosure framework where you're talking about, the risks and the attributes of the crypto asset itself, of the token itself? We are trying to push and suggest that countries in a disclosure regime, for instance, embrace the latter, because I think we'd all agree, an issuer-based disclosure framework for something like Ether or the Ethereum blockchain doesn't make any sense, right? What's the financial statement and the financial condition and the balance sheet of the Ethereum blockchain? And what kind of information, if you even decided that you could, conceptualize that, why would that be important to people? As opposed to a generalized disclosure that can be satisfied with publicly available information that provides people with the benefit of understanding what the true risks are of purchasing an individual token. And France is on there too. France is kind of a standout within the EU. They've been much more positive in regards to their approach to crypto assets, although it's kind of TBD on whether or not their approach is going to be subsumed by, the EU-wide approach through ESMA. So those are dynamics we're following closely. And now I'll turn it over to Michele for her presentation, and then I'll come back up to answer questions.
Okay, although we had the disclosure slide because I am barred in 2 states, I have to tell you this isn't legal advice that I'm giving you, but I hope you'll find it useful. Interestingly, we've got a lot of different jurisdictions that we have to think about. I'm going to generally go over the alphabet soup of the US, but as you know, and as Brian talked about in the last slide, we have comparable regulators for various types of activities and businesses in those international jurisdictions that are going to be the equivalents as well. So the question is often, who has jurisdiction for what? And often it's going to be overlapping jurisdiction for these various different types of agencies, depending on really the activity that you're engaged in. The other thing is that a lot of people think that where you incorporate or where your offices are is going to dictate who regulates or supervises you. And in fact, what's really going to be the most important factor in who is your supervisor and what laws you have to follow is where you're offering services. And so, we see that in the United States where we have the federal regulators, but if you're also offering services, depending on the type of services, to individual state residents, then you may have to have licensing requirements in those individual states. And the same is going to be true internationally. So if you're offering, say, you're a money transmitter in Japan, then you're going to have to follow those laws and perhaps license or register with the JFSA in Japan. But just to kind of put them in buckets, we have the banking agencies that probably touch the types of businesses that you guys are building, not as much as, say, some of the large like exchanges and custodian offerings. But the markets and investing, those agencies, the SEC, Securities and Exchange Commission, which I'm sure everyone is familiar with, the CFTC, where Brian was a commissioner, and also the FTC. Those are the agencies that are really looking at the markets, consumer protection, and when you're thinking about token design, whether or not it's a security, how is it classified, what types of disclosures do you have to give, do you have to register or license, depending on the jurisdiction. Those are things that you're going to need to think about very, very early, because obviously token design, if that is a part of your business, is going to be affected by those agencies and their laws. Then the national security and kind of financial services types of businesses. So this is going to be money transmission, and then thinking about tax issues. Those are all going to fall into the bucket of the Treasury agencies. So that's the Financial Crimes Enforcement Network. That's where I worked prior to coming to A16Z 2 years ago. If you are a bank or a money transmitter, then you will have to comply with certain laws. This is what you commonly hear about, the AML programs, where you have to KYC, and there's a lot of give and take there because it's a facts and circumstances evaluation as to whether you actually have those obligations. And we used to say that one of the most important factors was whether or not you were custodial or held private keys. If any of you have been following some of the both enforcement actions and criminal cases that have been brought in the United States, that may not be the case going forward. That there could be certain activities or business models that even if you're not holding private keys, you could be considered a money transmitter. These are important things to think about. But obviously, we've seen that there are bad actors out there that are looking for ways to use the technology to make money, to hack, to launder. And so these are things that we need to be aware of. And then finally, as we discussed, there are state regulators that do have laws on the books that you may have to comply with. This mostly falls in like insurance, lending, financial type of activity. And so that's something to be aware of as well. So what I want to give you today is like kind of a quick high-level operating instructions and talk to you about the top regulatory issues that actually come up with Web3 businesses. So the first thing that I tend to to advise on, and that all of you need to be thinking about, regardless of whether you would be classified as a financial institution or a money transmitter, whatever. If you are moving any type of value on your platform, on your technology, your business, your app, you need to know that you have to follow the sanctions laws. And that is whether or not you are running the business in the United States or not. It's a very broad capture as far as their jurisdiction. You really only need a little bit of touch to the United States in order for you to have liability under the sanctions laws. And so these are things to think about. And the way you want to think about it, if you're not offering some kind of financial services that would have the AML or KYC obligations, you need to think, if I were a North Korean cyber criminal, how would I come and use this technology for my purposes, whether it's coming in and hacking, whether it's coming in and laundering crypto through the website or through an app or through the protocol? And what can I do to mitigate that risk that they're going to come and use my technology? And the reason why you need to think about this is that the civil enforcement of sanctions law does not require what we call a scienter element, which means you didn't have to intend to do it. You didn't even have to know that it happened. But if it does happen, you can be liable. And when I say liable, fines and penalties that can wipe out your business. It is a stain on your reputation that could cause you to lose banking relationships. So I'm not here to scare you and be the boogie woman here, but this is something that you all really want to think about. And there are excellent ways to address this with screening, blockchain analytics, and other things. And we can talk individually about those things if you like. Then the next question I get is, am I a money transmitter? Do I have to have an AML program? Do I have to KYC customers? Hey, I don't have account relationships with my users. We don't hold the private keys. Am I a money transmitter? What activity am I engaged in? And that's a question that comes up a lot with crypto. And so it's something that you want to think about, because there are, licenses in some countries that you would have to obtain, registrations in the United States, and it requires actually a lot of money and investment in compliance programs. And so these are things that you want to think about very early, because it may be that as you're building, that there are pivots that you can make with how your technology works. If you don't want to be in financial institution land, to take the business in a different direction that would prevent you from having to have those registrations and licenses and those regulatory obligations. The third question that comes up is tax. So we have a lot of pending regulations that are happening in the United States with the IRS, how they're going to determine how NFTs are taxed, how they think that staking should be addressed from a tax perspective. Those are all things that you just need to be watching. I will say that as you're setting up your businesses, and the questions that I get a lot, it's not just about where do I need to pay, and decisions that might be good for you as far as where you incorporate around the globe for tax benefits, but also, do you have reporting obligations? So depending on the users that are using your businesses or technologies, and what jurisdictions they're from, do I have tax reporting obligations on those users and their activities? And then finally, the thing that we love the most with securities laws, and how do we design and launch and build our tokens and our token ecosystems. And so those are questions that, as I mentioned before, you're going to want to think about and start consulting with either the resources available at our team, or with outside attorneys that have expertise in this area. So those are really the top kind of regulatory questions that come up in the context of Web3 businesses. And then lastly, the other question that we often get is, how do I interact with regulators? And you have, as you can see on the screen, reactive and proactive. The reactive are unfortunately often unpleasant. You've heard about the Wells notices in the United States. That's when the SEC delivers a letter that says, we're investigating you and we're considering suing you or bringing charges. This is your chance to come in and talk to us and convince us why we shouldn't do this. You don't want one of those. You don't want a notice of investigation because it is unpleasant and you don't know how it's going to end, but also because it takes away resources that you want to use running your businesses. So these are things that could occur and why you want to proceed carefully. Talk to advisors, talk to lawyers about how you're building your business in order to avoid regulatory scrutiny. Sometimes people get subpoenas. I get calls from people who are panicked that the FBI emailed them or sent them a subpoena. And most of the time, actually 98% of the time, they're just looking for information in a case that has nothing to do with your business or your technology. They just seem to believe that there may be some information that you may have access to. And obviously, cooperating with them is helpful, but sometimes you may want to also talk to legal counsel. But that is something that's not out of the ordinary, and you shouldn't panic if you have law enforcement contacting you looking for information. And often, they are confused about where they need to go and where the information is held, and often it's just an email or phone call to explain, hey, like, we're a protocol, we don't store any data, you're looking in the wrong place, but maybe over here they may have some information about the customer or the transaction or the activity that you're interested in. And then the proactive interaction with regulators, which can be really great opportunities for them to learn about what you're building and how the technology is progressing. And as Brian mentioned, helps them to learn and understand what it is that we're doing so that they can craft the regulations in a way that's going to allow the businesses to thrive. And I would encourage interaction at conferences where they're asking for demos of products that they may be interested in. There are opportunities to actually interact in a positive way with regulators, even though what we often read in the news is all of the bad interactions. So just a couple of examples of how we've seen the context of some of these regulatory issues come up. One was an NFT company that basically operates like a layaway or a mortgage. And we were able to determine with some consultation that they needed to get lending licenses. And so they're boutique law firms that actually can do that for you in all 50 states or in other countries if you're servicing customers in those jurisdictions. Wallets in the UK. Recently, we had a financial promotions regime that was enacted last summer. And we had a number of wallet companies that needed to figure out, hey, is the functionality that we have with our technology, is that going to be captured by this law? And trying to figure that out. And sometimes the answer isn't clear and you just have to make a risk-based assessment as to whether you think that you might be captured under that regulatory regime. And if so, what are the consequences if you don't get licensed or follow whatever the laws are that they're proposing that you have to follow in the particular example. Here, there were some wallet companies that said, you know what, we don't have that much visibility or that many users in the UK. We're going to just turn off the lights until we feel more sure about what the market, how this is going to pan out. But others said, hey, we think the risk is small, that they'll determine that the way we function, that we're covered, so we're going to keep going, and we don't believe that we fall under the law. So these are all discussions that are very fact-specific to your business. And then finally, with the IRS rulemaking that I had mentioned, they're looking for information about NFTs, about staking, about your technologies, and so interacting in responses to comment letters. We had a number of companies that actually filed responses themselves in addition to responses that we filed. And one of the reasons why you want to be aware of these kind of circumstances, if they might affect you, is that if the law comes into effect, any law comes into effect that could affect your business in a negative way or a way that you don't want. If you have participated in the rulemaking process, in most instances, that's going to give you legal standing to be able to bring a lawsuit to challenge it. So these are all things to think about why some proactive policy work sometimes is really beneficial to your business, because it may give you legal protection if the laws don't turn out to your best advantage. To close, we all need regulations. They're important for these policy objectives, making sure that we're protecting consumers from the casinos, right? And that there's a fair playing field, and that we're doing things that aren't going to allow North Korea and other bad actors to use our technology for bad purposes. There are a lot of moving parts. The landscape is changing. I want you all to think about all of these things, as you're building the business. It's easier, right, to make design and business decisions that are going to affect these regulatory outcomes in the beginning, rather than having to change or fix or deal with a regulatory agency later once the business is fully baked and launched. And finally, attorneys are doing really well in this space because you need them and they need you. And when in doubt, you really should consult with outside counsel. And I would say, do your research or talk to us about lawyers that have the expertise in the area that you need the advice in. And with that, I think we're at time for questions.
Thank you for your presentation. I have a question about Wells' notice received by Uniswap. It seems that they did all the right things, but they still got that. And my understanding is that this will be like a multi-year process. So just curious if you have any thoughts on that particular event.
There are certain things that builders and companies can do to try to have the best fact pattern if an agency decides to investigate and bring a case against you. But some of the things that we have seen specifically by the SEC haven't necessarily abided by standard practice. That's the nicest way I can say it. I think there's no question that we're in a fight in the United States. And a lot of that is being driven by a regulator that is taking a very broad view that may have some significant legal challenges in their interpretations. That anything and everything in the space other than Bitcoin is part of their regulatory remit and jurisdiction, regardless of what the fact patterns say. And that's a process that we're dealing with. I think the innovation isn't going away. It's going to survive. It's going to be here longer than the current chairman of the SEC. If those cases are brought, and as they are adjudicated in court, I think the law will have an opportunity to be made much more clear, and I think to the benefit of the industry and good actors.
Yeah, I would agree that right now I think we're in a very good position in that there are a lot of affected parties in the private sector that are fighting, and there are lawsuits pending, and I have faith in the courts. You don't always get what you want, but I have faith that the courts are going to, maybe not in all instances, but in some instances, give us more clarity and information that perhaps will cause the agencies to either go in a different direction or scratch their heads about whether or not this aggressive stance is appropriate.
And there's one more point there. I mean, I think the legal team can really, I think, dig into the facts of the case, but I think it's really relevant that in the SEC case against Coinbase, Coinbase won on the motion to dismiss that its wallet, was a broker dealer, and that fact pattern and that complaint is most similar to what the SEC may charge, Uniswap with. So they've already lost on kind of that major question and issue, but it doesn't seem to be diminishing their interest in relitigating.
Would love to get a sense of, you guys are in the thick of it. So I'm building a DeFi protocol for context, and would love to see what you see, coming down the pipe on your calendar that you look forward to finding out on rulings, and stuff over the next, call it 6 months. What the most critical things coming down the pipe are.
I think from a regulatory perspective, Michele and I work very close on kind of the regulatory perspective, especially if DeFi is involving derivatives because of, my background at the CFTC. And unfortunately, there's not a great story to tell there from the agency's approach to the space. They've been as intransigent in issuing new rules or in thinking about new frameworks as the SEC has, in its purview. So, I think the first question is, what's the area, of activity, that system is going to address, and then trying to think through, okay, well, what jurisdictions would pose the most, risk, most legal risk to you. In terms of broader frameworks, the UK, for instance, has announced that it is punting on considering DeFi rules, and we are working very hard to ensure that it is meant to focus on centralized intermediaries and token listings, et cetera, does not inadvertently scope DeFi in, and that, that they hold that promise. And then again, once they get to that step, I think we're going to have a very positive conversation with them about appropriate, scoping of those kinds of frameworks along that regulate apps, not protocols discussion that we had earlier. Others like the EU through MiCA have also decided to punt, but then you have the FSB, the Financial Stability Board, writing a report that starts to get a little bit more direct about its recommendations for different jurisdictions to be addressing DeFi risks. And then you have, some jurisdictions like the United States and others where they refuse to update their rules or consider, the benefits of the technology that pose some more direct risks. So I think it's jurisdiction by jurisdiction. There has been good news that some jurisdictions are deliberately punting, to be patient and thoughtful. We expect to be very active in those conversations, and I have some level of optimism that at least one jurisdiction is going to get this right, and that's going to. I think it's hard to underestimate the benefit that a jurisdiction getting this right will have in translating ultimately to good rules in other jurisdictions.
The other thing that you will want to watch from the money transmitting sanctions, that type of exposure for DeFi protocols, are the criminal cases that are currently being decided. So the Tornado Cash litigation, there's a pending motion to dismiss, and also the Samurai case that was just charged. Those cases are interesting because we've all been living in the world that the 2019 Treasury guidance, is the Bible, and if you don't have keys, then you don't have control, et cetera. And I think that in the context of those two cases, that they're looking, this is the first time we've really seen on paper that they're looking at it from a different perspective. And so I think watching to see both in the motions practice that happens before the cases go to trial, as well as what is the evidence that's presented in the trial, and what do juries think about this. I think those are going to be really important to focus on.
Awesome, thank you.
I have a follow-up question on the election. When we hear talks on legal stuff in crypto, there seems to be often a number of parties that get brought up, right? There's the administration, legislators, the agencies, and then also the courts. Is that because all of them will have to come together in agreement for crypto to be accepted in the United States, for example, in general? Or are the legislators more important because once they buy into it, they're going to create laws that will then be enacted or have to be enacted, and then the agencies will have to comply with that. How does that all mesh together? And if the legislators are the more important part, I wonder, I mean, there's probably A16Z, but there's others, like I think the Blockchain Association lobbies, I suppose, right? And I was wondering if the legislators have had enough opportunity to meet people building, like serious people building in the industry, because it seems that is where there's potential for them to understand this is serious, good for the economy, et cetera.
Great questions. And the first thing I would do is point you to the presentation that our head of government affairs, Colin McCune, made at our crypto startup school last year in Santa Monica, which I think is recorded and on YouTube, where he goes through a lot of the dynamics of Congress, the presidency, agencies, and how that process works. So I think to your point around election risk or election outcomes, it's really a big scenario analysis. Who controls the House? Who controls the Senate? Who controls the presidency? The presidency would then appoint regulators or replace, if it's Biden winning, he would replace existing regulators that are term limited. But those would have to go through a Senate confirmation, like I did when I was nominated. So then it depends on who's controlling the Senate, and would they agree to, approve the nomination of someone that, it may be hostile to either the technology or to their view of markets in general or to their view of the regulatory remit of that agency. So, there are a lot of moving pieces there. For instance, if the Senate's Republican and Biden wins the White House, there would be, a lot of kind of interaction around, potential new nominees for agencies, as some existing regulators, are term limited, have to move on. If Trump wins the White House, then the entire regulatory heads turn over, and then it becomes a question of, well, who is the nominated head? Are they likely to be confirmed through the Senate, given the Senate makeup? And what would be their, priority and strategy, and agenda in implementing, new potential rules in this technology? And if you're kind of stuck in kind of the current, scenario with agency heads, frankly, under either potential outcome with the White House that aren't moving on this technology or that are embracing hostility towards it, then depending on the makeup of the House and the Senate, they could always pass a new law. And we've seen the House take action through 2 committees on a very important bill, FIT 21, that creates a new market structure regime that has thresholds of decentralization in it that may be coming up to a vote on the House floor soon. If that isn't successful this year, it could likely, be on the floor again next year, and it could ultimately pass into law that then tells these agencies, you have to do this, and this is your framework for doing it. So it's a way of Congress then, passing that obligation to create new rules within a framework to those agencies, regardless of who the heads are in those agencies. But lawmaking is a very complicated process. There are a lot of checks and balances that were designed intentionally to, prevent bad ideas from becoming law, as opposed to allowing any idea to become law. And so, there will be a process, but as I said, I think this is a long-term game. The technology is here to stay, and ultimately the United States will get this right. But is it, this year, next year, 3-5 years, we'll see.
And to address your question about whether or not the legislators and the policymakers are actually interacting and having an opportunity to be exposed to the technology, the answer is yes, they have been for years. I think that it needs to continue because it's really helpful, particularly those who are kind of in the middle, the skeptics that just want to know more. Again, as he described, because you've got all of these different policy decision makers that potentially have different ideas about how this should be dealt with. I think that there's always an opportunity to be talking to them and educating them on all the beneficial aspects of the innovation.
And here's kind of something that's a little bit more direct to that. I mean, except for that group of policymakers that just fundamentally or politically oppose the technology, the entire rest of that audience, the more that they know about blockchains, crypto assets, and innovation, the more they support it. So it is an educational necessity to go in and have those conversations. We are doing that very actively. I have seen in real time, people's eyes light up, the light bulb go off, and them kind of saying, well, no one ever came in to talk to me about this stuff before. You're the first one that's done that. And I think part of that's just the relative youth of the industry from a lobbying perspective and educational perspective, some level of inexperience, focusing on just who the advocates already are as opposed to trying to broaden the appeal. But that is a process that we are significantly involved with and I think have had a lot of success with.
Thank you guys so much for your presentation. I'm Julie from Tweed. For context, we're in the wallet and payment space, so super relevant for us. My question is, it's pretty general, but considering the fact that young companies, we have obviously limited time and capital. We can't go out and get a legal opinion on what's considered custody or what's considered money transmission in every country in the world. But we do, it's a global industry. So what advice can you give in terms of balancing these two things? Do we just think about the key markets or the most advanced markets like Europe and a couple of others? Or do we think about, okay, where are the most users we think we're gonna have? How do you balance those two things?
So certainly there are plenty of companies, technologies that are squarely in the gray area and need to have expert legal consultation. But surprisingly, there are a number of meetings that we take where talking through the technology and how the business works, we can give you a pretty clear answer in many cases about what your obligations are. And then I think that particularly when it comes to, because you mentioned payments, say money transmission, even though you may have different regulatory requirements across different jurisdictions you may be serving, I think generally they're going to look at who falls into what bucket in a very, very similar way. And so usually if you can determine, okay, we are a money transmitter or we're not in the United States under the Bank Secrecy Act, that's going to tell us whether we would also be classified as that in these other jurisdictions. So I think that there is a lot of certainty, and it's in some aspects. And although there may be slightly differing obligations as far as licensing or registration or what they're going to require in different jurisdictions, that takes some work. Even in the United States, if you're a money transmitter, getting MTL licenses in all 50 states. But what we have done here is, in addition to kind of trying to give you some guidance, we have a very thick black book of legal help and people who actually perform these functions. And I will tell you, sometimes it's a really hard legal issue that I'm going to say, you need to go talk to this international law firm who is the expert in this, and it's going to be expensive. But in other cases, we've identified boutique firms that are very cost effective, that are happy to work with startups, that often are not that expensive, or they're happy to take on your business as you're getting started at a sliding scale fee, hoping that you will be happy with the services that they've given to you and that you're going to come back as a repeat client. So don't get freaked out about all the different jurisdictions and all the laws. I think, you've got a lot of help. We're all in this together. We've been working on a lot of the same issues over and over again. And so I think you're going to be successful in getting direction. And then there are resources out there that you can be referred to that aren't astronomically expensive.
I've got a question on, I think, the presentation. You mentioned considering regulatory risk and obligations early. So my question is, when what you're building straddles across, you could say, multiple industries and their respective regulatory regimes, how do you kind of consider these? I guess what I'm trying to say is we're building a marketplace that straddles across AI regulations, data and privacy, and you could say the tokenization regulations, and operating in regulatory uncertainty is almost a default state. So are there any sort of guiding principles or frameworks you recommend when it's almost as if there's multiple kind of regulatory sort of regimes that you kind of have to think about?
Well, I was going to just preface kind of maybe an answer to that by saying you're right. There are a lot of policy conversations that are going on around those different areas, and I think we can help try to preview with you where the most immediate action may be in which jurisdiction, so you have some level of an ability to focus. But to the extent that there are laws on the books already, depending on what other activities or markets that touches, that would be something that the regulatory and legal team can
And the
help you
legal
address.
team as well. Yeah. And it goes to what I was mentioning to, was it Julie? Again, assessing that, maybe prioritizing your focus based on who we know is most active from a regulatory agency perspective in certain jurisdictions. And then, making an assessment about what are the actions that you need to proactively take where you are certain about what your regulatory obligations are. I mean, obviously we want, investments of ours to be following the law. It doesn't make any sense to spend all the time building these wonderful businesses if you're going to have to spend all of your time fighting regulatory action. And so I think just doing those assessments and consultations early on is really, the best advice that we can give you. And it's probably not the type of thing that you thought that you needed to focus on as you're building a startup. But that's why we have these presentations during the accelerator, because we want everybody to think about pacing themselves and even thinking about budgeting for perhaps having to license with particular regulators for whatever activity that you're engaged in various jurisdictions.
We usually hear about companies, blockchain startups, very actively trying to avoid being classified as a security. Have you encountered cases where they want to do the opposite and own that they are a security and maybe trying to get benefits from being open about this?
So I think there's an interesting opportunity in the UK in that regard, because the FCA, through HMT's work, has launched a digital security sandbox. And they are currently consulting on the framework of that, its cost, fees, scope, et cetera. And Aidan's done a lot of work researching that, and we're happy to provide some of that information to anyone that might be interested to understand whether or not we should submit a response, as a comment letter to that, to help frame it more appropriately to anyone's interest. I think in the United States, it's been a little bit of the opposite. You have seen entities go into the SEC to try to attain, a special registration designation to launch a token, and they have died there. They have not been able to escape. They haven't been able to follow the rules imposed upon them. And again, I think that's because there's a refusal to provide any kind of new framework that fits the technology. So I think it's a jurisdiction question. But obviously it depends on what the innovation is that anyone is building. If it's designed to be efficiencies in securities transactions through blockchains, then there are sandboxes and there are programs in other jurisdictions that are actively considering that, because a lot of these jurisdictions want to have a better, want to compete more on the status of their financial markets, and certainly their equities marketplaces. So they're actively exploring those things and trying to take advantage of the fact that the United States is not.
I'm wondering if you guys have seen a major shift in the way policy is being directed towards a technology and the way regulation is enforcing that over your careers. More explicitly, is the last 4 years like an aberration in the aggressive regulation by enforcement that we've seen? And that's something that's like an outlier that we should view in our mental models as, hey, things are very different? Or is this sort of par for the course, as they say, just looking back over your careers and what you've experienced in them?
Yeah, that's a complicated question. I think partly because I think when I first joined the CFTC, it was late 2017, and I had a very long nomination and confirmation process that lasted, I don't know, 4 years. And during all of that time, I didn't do any research on crypto assets, blockchains, et cetera. I was focused on Dodd-Frank implementation. But then 3 months into my tenure, we had the CME group self-certified Bitcoin futures contracts, and it launched the agency directly into the crypto ecosystem, discussions around the viability of the technology, and in the intergovernmental and international debate around regulatory approaches to crypto. So it hasn't been that long, I think, from my perspective, to have a good snapshot, or data set there. I think, to me, I think you are seeing a much stronger and wider spread reaction to the negative and aggressive enforcement approach, to think that it's going to be sustainable or that it's going to be something that continues to repeat. However, once something becomes, in the kind of the political, it gets politicized and becomes part of the political zeitgeist, then you can have scenarios where you ping pong back and forth between different, administrations or parties and control, et cetera. I'm not convinced that that's happening. I think it's much, the approach that we've seen is much more isolationist, and the breadth of the enforcement is somewhat unique to this, given how outside of the traditional bounds of the law and traditional approaches to regulation it is. I don't think it's sustainable, and I think it takes a unique individual to be able to try to stomach that, that approach. So I guess my answer to that is that I don't think we've had enough time, but I think that, as I said before, the more policymakers know about this technology, the more supportive they get. I expect that trend to continue. That, I think, helps to diminish the potential that this becomes kind of a ping pong back and forth between different administrations over time. Thank you very much. It's a pleasure to be here, and we're excited to interact with you today, tomorrow, and through the rest of the week.